Hey everyone, it's Jullien Gordon again. I just want to say thank you for everybody who helped on social media to attract and galvanize as many investors as possible. We've been able to apply a lot of pressure to the Tulsa Real Estate Fund and even to the SEC to get the ball rolling, and we did get a response. And so I just want to say thank you. I'm not going to be on video in large right now because I want to be clear that this is not a personal thing between Jay Morrison and I. I just happen to be representing the investors to the best of my ability at this moment in time. Against the fund, unfortunately. And so I will actually be reading from this speech, and you will all have access to this transcript afterwards. Dear fellow Tulsa Real Estate Fund investors, my name is Jullien Gordon, and I'm the lead investor in the Tulsa Real Estate Fund at $40,000 invested. For context, if you missed my speech from last week, you can find it at this YouTube link. And again, I'll provide this with you for you all. Jay Morrison has responded to my speech on Instagram and via email, denying all claims, and he has invited us to TREF Talks Live at the Black House on Tuesday, September 5th at 6 p.m. Eastern Standard Time. Today's speech will be different as I will be using screen sharing and visuals to show evidence of what I was talking about last week. I'll be showing evidence of what I think is classified as fraud or gross mismanagement of funds. This full speech transcript with clickable links will be available at TulsaRealEstateFraud.com, TulsaRealEstateFraud.com, so that you can conduct the research for yourself. Do not just believe me, go conduct the research for yourself. In short, I'm here to let you know that the Tulsa Real Estate Fund is almost bankrupt and there is potential fraud. Again, potential fraud. As of June 30th, 2022, the fund only had $1.48 million in cash from the original $11 million. The $11 million is only worth $3.2 million now, and that's a loss of 70% or $7.8 million over the last 5 years. And so just to show you those numbers, I'm going to teach you how to read through the SEC filings right now. So this 1.48 in cash, you'll find that on the balance sheet, and that's cash and cash equivalents right here. The 3.2 million that our shares are now worth is down here. Okay, total members capital. So you're starting to learn how to read these SEC documents for yourself. From June 30th, 2021 to 2022, it took another $1 million loss. So in that year, the fund took another $1 million loss, and you will find that right here. June 30th, 2021 to June 30th, 2022, it took another $1 million loss, okay? So that's about $1 million loss per year. So given that we are in August of 2023, over a year after June 2022, the fund likely has less than $500,000 left in cash, and the fund only has acquired $4.29 million worth of actual real estate. A real estate fund has only acquired $4.29 million in real estate assets, which only represents 39% of our original investment. So where do we find that number? We find that number right here, total real estate assets, okay? So moving forward, only 39% has gone to actual real estate, okay? So moving forward, and all the visuals will be here. So investors beware, investors beware, investors beware. Jay Morrison will continue to say that the SEC, Security and Exchange Commission, and DOJ, the Department of Justice, investigated the fund in its first 6 months and had no findings. And that is true. But there was not much to find in the first 6 months. The things that I'm talking about occurred after the initial investigation. Okay, so don't let his smooth talking fool you and you believe that, oh, just because they found no findings early, that proceeds forth into the 4 years that have transpired since then. Okay, so be very careful. He has a way with words. Since the last SEC investigation, we have evidence that Jay Morrison has misappropriated funds, violating his fiduciary duty to investors by, one, this is unbelievable, buying his personal residence at 3900 DeMooney Road in South Fulton, Georgia, 30349, masked through anonymous LLCs. 2, refinancing his own investment properties and having certain fees and penalties forgiven that benefit him and not the actual fund or investors. As investors, we want the fund to cease operations, liquidate all assets, and return to us 20% of our initial investment so that we don't end up with 0%. The purpose of this video is to show investors the actual evidence. You're going to see a lot of visuals in this particular talk. Show investors the evidence I've gathered regarding the 2 claims mentioned above, and there may be more. Okay. Demand documents from the Tulsa Real Estate Fund leadership team by 5 p.m. Eastern Standard Time on Monday, September 4th, 2023, so that we can review them one day in advance and ask questions based on facts on the 5th as opposed to feelings. Okay. We also want to demand how we would like the September 5th TREF Talks Town Hall meeting to be structured and run. And then 4, provide research-based questions for investors to ask at the town hall meeting. After last week's speech about my disappointment in the Tulsa Real Estate Fund as the lead investor, a fellow real estate developer and a former friend of Jay Morrison, a lot has transpired. After blocking me on social media, Jay Morrison invited the public, not just investors, the public, to a town hall meeting on Tuesday, September 5th at 7 p.m. Doors open at 6 p.m. at the Legacy Center. This is the invitation. He's also sent out an email invitation to all investors, so check your email if you're an investor. TREF's email sent today states that the meeting will be live streamed, but I'm not sure if it will be live streamed at our normal monthly TREF Talk Zoom link here. So you'll be able to click this. I'm not sure if a new link will be sent out for this particular meeting. Nonetheless, we celebrate the fact that our voices will finally be heard. Despite this opportunity, Jay Morrison still intends to control the conversation to the best of his ability, like he does in Zoom, by closing chat and cherry-picking questions. We have a list of demands below to level the playing field and make this operate more like a real board meeting rather than a town hall meeting in the absence of a true actual board of directors. Secondly, since last Thursday's speech, I've gathered what I believe to be sufficient evidence to prove 2 potential, I repeat, potential illegal violations of Jay's fiduciary duty to investors, which I will share and lay out in detail in this video, but ultimately the SEC and the DOJ will have to make that judgment. While Jay Morrison has written the subscription agreement that we all sign before investing in a way that gives him totalitarian authority over the fund, he is still subject to his fiduciary duty and cannot commit fraud, act in bad faith, partake in material violation, or gross negligence, which are all defined below, but subject to interpretation in the court of law. Allow me to define these terms. Fraud, wrongful or criminal deception intended to result in financial or personal gain. I believe that he has committed fraud. Fiduciary duty, the legal responsibility to act solely in the best interest of investors. I do not believe that he has done that. Bad faith, intent to deceive. I have evidence of that. Material violation, the act of failing to accomplish a requirement of law. And gross negligence, a person's conduct where an act or failure to act creates an unreasonable risk or harm to another because of the person's failure to exercise slight care or diligence. And I believe that that has occurred. That is the only way you burn through $7.8 million in 5 years and have really nothing to show for it except for the Black House, which was recently refinanced. So we actually only own 25% of the Black House at this time. Okay. So our first claim. Jay Morrison used TREF funds to buy his personal residence in cash at 3900 DeMooney Road, South Fulton, Georgia, 30349, masked to anonymous LLCs, and then refinanced that residence, potentially using TREF funds at an undisclosed interest rate, which suggests fraud or financial or personal gain. Violation of fiduciary duty, but not disclosing his personal interest in this transaction, like he properly did for 862 and 875 Parsons, but he did not do it for this one because it was likely his personal residence, and bad faith or intent to deceive based on the definitions above. Our second claim is that Jay Morrison refinanced his own investment properties at 862 and 875 Parsons at Atlanta, Georgia, held by JM Rep 23 LLC using TREF money. While he did disclose his potential conflict of interest, he forgave himself of $12,000 in exit fees when he was not equally forgiving other developers, which suggests fraud or personal gain based on the definition of fraud above. The 2 claims mentioned above came after the initial investigations concluded by the SEC and DOJ. He must have thought that he was free and clear and that they would not circle the block again. This leads me to number 3. Thank you to social media. I've been able to identify and galvanize a few thousand investors who have submitted complaints to the SEC, submitted redemption requests to the Tulsa Real Estate Fund, as well as emailed the fund at info@tulsarealestatefund.com, and Thomas Cluck from the SEC, who was the initial investigator. For those of you wondering why I had to go public, is because Jay Morrison wrote the Tulsa Real Estate Fund subscription agreement in a way that is almost impossible for any one of us to impossible for us or anyone except the SEC or DOJ to hold him accountable. It actually requires, you can see, for example, dissolution of the company. Members holding 75% of Class A interest can vote to dissolve the company. However, the company can dissolve as a result of other actions that do not require the vote of the members as set forth in the operating agreement. So I would have to get 75% of investors, right, together, or that own 75% of the fund, in order to actually move any action forward. And given that we have no way to connect with one another, that would be almost impossible. And so that's why I've had to go to social media, even though I've been reluctant to. Okay. So I need to unite about 11,000 people of approximately the 15,000 investors to make any moves. There's no other way that I know how to do that, especially since the Tulsa Real Estate Fund's Facebook group was shut down as of January 17th, 2022. Okay. So you can see that screenshot right here. The group was paused as of January 17th, 2022. And this is when a lot of the stuff went awry. So it's no wonder that that group was frozen, so that we could not connect as investors and our voices be heard. Okay. I'm going to jump into the fraud claims in just a second. But as we get ready for the September 5th meeting, we have some requests from the organization that we want to be made known. September 5th, TREF Talks board deck documents requested by 5 p.m. Eastern Standard Time on Monday, September 4th via email. We would like to treat this like a real board meeting in the absence of a true board of directors. Board meetings require that the manager, executive, or leader supply a board deck that has data and documents to discuss. This meeting should be based on fact, not feelings or personal relationships. We are asking that the TREF leadership team please make these documents public to investors by 5 p.m. Eastern Standard Time on Monday, September 4th, so that we can have close to 24 hours to review the documents before the town hall meeting. Please email them to us using a Dropbox or Google Drive folder. The forms filed on the SEC website do not address all of our questions. For instance, the GMA or General Marketing and Administrative line item in the SEC filings is too general, and we would like it to be itemized so that we can see why that expense is growing so large. It is one of our biggest expenses in the fund, and you can see that line item right here, $929,000, 1.4 million. We have no clue what's in there, and it grew by 53% in the last filing period. All right. So the board deck and our document request, I'm going to skim through these, but we're just making this verbally known and also written in writing that to the fund's leadership that we would like these. We would like the current cash balance. Like literally just go to the bank account and let us know what is the current cash balance of the fund. More details explaining that are there. We would like the 2022 income statements and balance sheet. Okay. We would like the 2023 income statements and balance sheets from July 1st, 2022 to June 30th, 2023. QuickBooks and other accounting softwares easily generate these reports year to date. Okay, so please include an updated version of this slide based on the books as of Friday, September 1st at 5 p.m. So on Friday, right, please just turn these into a PDF and actually get them to us. And we would also like a version of this slide, which I think he presented at the Black Wall Street Gala. Okay, so we know that the information is there. We are asking for it now so that we do not have to wait for the SEC filings. We are also asking for evidence of the SEC compliance budget. Here, Jay has shown $590,000 in legal fees, but verbally he has said there's been $2 million in compliance. That $2 million of the fund went towards just compliance. We would like to see evidence of that. So that's there. We would like a visual chart of all the entities. This has become a very complex entity, especially when you bring in Jay's other LLCs that he owns. And so we would like a visual chart to be able to understand all of these entities and how they work together. We want to see employee compensation by year, all employees that have been paid, even if they no longer work with the organization. And we want you to use this particular template and chart right here. We want to see vendor payment by year. This will help us break down the GMA expense. So we want to see all vendors being paid. We know that his wife has been paid as a consultant. We would like to see what her company has charged or been paid by the company, by the fund, as well as any other vendors, many of them being Jay's friends and associates that he has paid. Okay. We'd also like to see assets owned. We need a very clear distinction of assets owned versus assets funded. Okay. Those are two different things. And then we would like proof of we would also like to see proof of rental payments by Jay Morrison's entities that inhabit the Black House. We would like to see proof of payments to the Tulsa Real Estate Fund, also for his mortgages to the Tulsa Real Estate Fund, and transactional funding decision sheet. So the website says that 88 developers have tried to get funded through TREF. Only 25 have actually received money. We would like to see that documented using this particular chart and table here. All right. Now, real quick before I get into the evidence that I have of fraud. On September 5th, TREF Talks in person at 6 p.m. at the Legacy Center. This is the address. It is 3015 RN Martin Street in East Point, Georgia, 30344. As stated above, we would like to treat this like a real board meeting in the absence of a true board of directors. And so here are requests for the meetings. Please have East Point Police present outside and inside. Please send out the live stream link 24 hours in advance. Please have our proper videography team and equipment to record the entire event from 3 angles and good audio quality. Please provide all of the board deck documents requested above that I just stated. Please set up in the largest room possible to ensure that there are no capacity constraints. If there are capacity constraints, please give priority admission to investors. Please have a list of investors at the door and provide investors with a red wristband so that they can be easily identified during the open mic. Please honor your word and from your video and stay until there are no more questions. He has already reneged on that, saying that it will start at 7 p.m. and end at 9:30 p.m. 2.5 hours will not be enough. Please have 3 standing microphones on the floor and 1 handheld mic on the floor for any elderly folk that cannot stand easily. Please start on time please open the doors at 6 p.m. sharp and start on time at 7 p.m. sharp. Okay. Please bring the Tulsa Real Estate Fund team to answer any detailed questions that Jay Morrison cannot answer himself. Please have a projector attached to a computer so that you can readily pull up documents and reports in real time that we request. Please allow investors to come up on stage and use that very same computer to present their own evidence using a USB drive. Please ensure that Wi-Fi is available in the entire building. Please have water available for attendees. Please make sure that the bathrooms are functioning, and please make sure that the space is air conditioned and remains at a comfortable temperature between 72 to 75 degrees so that people feel comfortable staying. Okay. And investors, please wear red so that we can identify each other easily. All right. I've also listed out questions for all investors. I've listed out questions that you may consider asking at the mic about 3900 Damuni, financial questions here. Okay. Structure questions here, team questions here, business model questions here, management fee questions here, intermingling questions here, and legacy center rental questions here. All right. So I've laid all that out. Look at those questions, but of course, come with your own. So now into the 2 potential fraud claims. I would like to go there. Before we establish any claims, let's explore the legalese or the legal language regarding the manager's fiduciary duty. You hear Jay use that terminology a lot to try to sound smart. This part may be a little dry, but it is necessary to start from here so that you understand what we are arguing, okay? The Tulsa Real Estate Fund's company formation agreement states the following regarding the fiduciary duty of the manager. Even though his subscription agreement is written in a way that protects him and allows him to do almost anything, you cannot sidestep your fiduciary duty. And that company formation agreement can be found at the SEC's on the SEC's database here. Just click that link, okay? And it was filed 5/2/2017. In 6.9, you will find the fiduciary duties of manager. The fiduciary duties the manager owes to the company and other members include only the duty of care, the duty of disclosure, and the duty of loyalty as set forth below. A member has a right to expect that the manager will do the following: use its best efforts when acting on the company's behalf, not act in any manner adverse or contrary to the company or members' interests, not act on its own behalf in relation to its own interests unless doing so is in the best interest of the company and it's fair and reasonable under the circumstances, and exercise all of the skill, care, and due diligence at its disposal. In addition, the manager is required to make truthful, and complete disclosure so that the members can make informed decisions. The manager is forbidden to obtain an advantage at the expense of any of the members without prior disclosure to the company and its members. And I believe that that has happened, and I will show you that in just a second. 6.9.1, the duty of care and business judgment rule. Just as officers and directors of corporations owe a duty to their shareholders, the manager is required to perform its duties with care, skill, diligence, and prudence of like like persons in like positions. The manager will be required to make decisions employing the diligence, care, and skill an ordinary prudent person would exercise in the management of their own affairs. The business's judgment rules should be the standard applied when determining what constitutes care, skill, diligence, and prudence of like person in like positions. This one is very, very key, everyone, before we get into claim number 1. 6.9.2. Duty of disclosure. The manager has an affirmative duty to disclose material fact to the members. Information is considered material if there is substantial likelihood that a reasonable investor would consider it important to make an investment decision. The manager must not make any true statements to the members and must not untrue statements, must not make any untrue statements to the members and must not omit, this is very key, must not omit disclosing any material facts to the members. The manager has a further duty to disclose conflicts of interest, which you will see in this first claim, that may exist between the interests of the manager and its affiliates and the interests of the company and any individual members. I believe that the following 2 claims violate the fiduciary duty of the manager listed above. Okay, so claim number 1, 3900 DeMooney. Okay. Jay Morrison used TREF funds to buy his personal residence in cash at 3900 DeMooney Road, South Fulton, Georgia, 30349, mass through anonymous LLCs, and then refinancing that residence, potentially using TREF funds at an undisclosed interest rate, which suggests fraud for financial or personal gain. Violation of fiduciary duty by not disclosing his personal interest in this transaction like he did properly on 862 and 875, but he did not do it here. And so he knows what is right, but in this transaction, he did not do right. And bad faith, intent to deceive based on the definitions above, okay? The property that is in question, everybody, is 6 West 1 and 6 West 2. Notice that on the Tulsa Real Estate Fund site, this is the only property on the website that has no address listed, okay? See, there are addresses on all of these videos except for what? This one right here. Why? Because I don't want to disclose my personal residence. It's the only one that does not have an address. The official addresses for 6 West 1 and 6 West 2 are 3878 DeMooney and 3900 DeMooney, or the other way around. I don't know how internally they chose to name them, okay? So that's a first key. In this video, Jay Morrison calls it an assemblage of 32 acres, when in fact the fund only owns about 5 acres next door to Jay Morrison's 25-acre estate. It's not just a house, it's an estate with acreage, okay? And what the fund, so in this video, it makes it look like the fund acquired 32 acres for $150,000. That is not true, and I'm going to show you evidence of that in this presentation. The fund's 5 acres are at 3878 DeMooney, and you can see that on the Fulton County Assessor's website right here. This blue area is what the fund owns. You see Tulsa Real Estate Fund LLC right here. That's what the fund owns, okay? Jay Morrison's 25 acres are at 3900 DeMooney. This is his estate right here, okay? Morrison Jermaine Dyshawn, okay? That is his estate right there, okay? And on Zillow, you can see $850,000. And then the fund acquired this for the $150,000. So this was a $1 million transaction. All right. Again, you can go to the Fulton County Assessor's website, type in those addresses, and see this information for yourself. All right. If you're still questioning whether this is his primary residence, watch this. First, you can see a screenshot from his Instagram of his daughter on the land with the caption, "When your baby's backyard is 27 acres of farmland." So this is the screenshot captured by Follow the Paperwork. That is Jay's daughter. When your baby's backyard is 27 acres of farmland. And you see this green house right here with this white shed, with this white roof. It is all, and this is his Instagram right here. That same green house with the white shed, with the white roof is right here. Okay. So she was standing around here in that picture. All right. Now, on to how he hid this transaction from investors, even though he was supposed to disclose this according to the company's agreement. Remember, the agreement said the manager must not make any untrue statements to its members and must not omit disclosing any material facts to the members. The manager has a further duty to disclose conflicts of interest that may exist between the interests of the manager and its affiliates and in the interest of the company or any of the individual members. So this clearly violates the fiduciary duty of the manager. After reading through the SEC filings, I have not seen any disclosure of this material fact or conflict of interest that Jay Morrison used TREF funds to acquire his primary residence. He looked directly into the camera and omitted, okay, and this says must not omit, omitted this material fact that I, Jay Morrison, purchased my primary residence or home with the fund's money. It's all there, family. In the Form 1 essay filed on July 24th, 2023, for the period ending June 30th, 2021, it states 6 West 1 and 6 West 2. In July of 2022, the company invested approximately $960,000, okay, for 2 adjacent properties in Atlanta, Georgia. This purchase is part of a plan to secure controlling interest of 32 acres of land to either develop the property or resell for profit. So we're going to stop there for a moment, okay? The SEC documents say the company invested approximately $960,000 for 2 adjacent properties in Atlanta, Georgia. Why we need to make approximations when HUD-1 settlement statements and assessors' websites have exact numbers makes no sense to me. Where's the other $40,000? Okay? Now, the Fulton County Assessor's Office tells a different story, that the company tells a different story. On July 27, 2022, TREF purchased 3878 DeMooney, the 5-acre lot, for $150,000. And you can see that right here. Tulsa Real Estate Fund, LLC, July 27th, 2022, $150,000. Okay, you see that? What about the other lot? On July 27th, 2022, the same day, 3900 DeMooney LLC. DeMooney LLC purchased the 25-acre property with the house on it. That's $1 million in total, but the SEC documents only show $960,000, and the SEC documents state that the company, TREF, invested the $960,000, not another entity, right? And so here you have the $850,000 transaction, okay? And this transaction, Jay currently owns that property personally, but you'll see, I'll walk through these 3 transactions right here. This one right here is when Chang, Chen, Chu, Leo, okay, and such actually sold the property. The grantor sold the property to the grantee, 3900 DeMooney LLC, okay? In the same Form 1 essay filed on July 24, 2023, it states that these are wholly owned subsidiaries owned by the company, okay? So does TREF own 3900 DeMooney LLC, right? If TREF LLC purchased the 5-acre lot, who is the entity, who owns the entity that purchased the other lot, okay? So as you can see, these are the subsidiaries of TREF, okay? TREF Legacy Center LLC, JM Rep 28 LLC, and Legacy Spaces LLC. 3900 DeMooney LLC is not listed as a subsidiary. So TREF actually did not purchase, okay, from an ownership standpoint, but from a monetary standpoint, the money may have come from TREF to purchase this, and you'll see why in just a second. So who owns 3900 DeMooney LLC? Of course, none other than Jay Morrison, based on the articles of incorporation below, where he is listed as the registered agent and the manager. Okay, and you can go to the state of Georgia, Treasury, and actually go do the search yourself. Okay, and so I'm going to pull up that image, state of Georgia, 3900 DeMooney LLC. Okay, that's the certificate of organization. And here is the business name right here. Organizer, Jay Morrison. Manager, Jay Morrison. So the SEC documents say that TREF put the $960,000 in to buy these properties. But the assessor's website says two different things, that TREF bought the 5-acre lot and that Jay Morrison through 3900 DeMooney LLC actually bought the other lot. But where did all the money come from? Did it come from Jay Morrison in cash? Did the $850,000 come from Jay Morrison in cash? And if it did, why is it saying that TREF, okay? Why is it saying that TREF made the purchase of $960,000? All right. Are you starting to see where it's getting convoluted? To test if this was just a mistake, let's look at TREF Legacy Center LLC's and Legacy Spaces LLC's articles of incorporation and see who the organizer is. In both cases, it is the Tulsa Real Estate Fund LLC, not Jay Morrison, the individual. So this isn't an error, okay? So the two wholly owned LLCs owned by TREF, okay? You can see that TREF LLC is the organizer. That is for TREF Legacy Center LLC. And then for Legacy Spaces LLC, TREF again is the organizer, not Jay Morrison. So this was not a mistake, family. So Jay Morrison is the organizer and manager of 3900 DeMooney LLC. And it is likely that he used TREF funds to buy 3900 DeMooney Road in South Fulton or College Park, Georgia at 30349, which is the 25 acres with the house with 3900 DeMooney LLC. Okay. So we would like to see a paper trail of that. Who actually wired the money to the Asian family that sold the two lots? Who wired that money? Was it TREF or did it come directly from Jay Morrison? Now, to hide this, Jay then deeded the property to South Fulton Rentals Group LLC, which is an anonymous LLC started in New Mexico on August 4th, 2022 for $0 on August 19th, 2022. It is highly likely that Jay Morrison owns South Fulton Rental Groups LLC. Okay, it is anonymous LLC, so that means you cannot track the individual who actually owns it, but it is likely that Jay Morrison owns it. This is why he incorporated it in New Mexico. And here are the incorporation documents for South Fulton Rentals Group LLC in New Mexico, but New Mexico has anonymity. All right, so so you can see that it was sold from 3900 DeMooney LLC to South Fulton Rentals Group LLC for $0. So basically that it got deeded over to this anonymous entity. It got deeded over to this anonymous entity. Now, after that, on May 31st, right here, 2023, South Fulton Rentals Group LLC sold the property to Jay Morrison for $80. South Fulton Rentals Group LLC sold the property to Jay Morrison. What is that? Almost 10 months later for $80. In other words, he sold the property to himself, right? So you can see South Fulton Rentals Group LLC now grants this property to Jermaine Morrison. I don't remember any of this being disclosed, that the fund was acquiring property that included Jay Morrison's personal residence. So now let's go back and look at the lies in the SEC filing, okay? So it says in July of 2022, the company invested $960,000 for two adjacent properties in Atlanta, Georgia, okay? The company, which is TREF, never owned both properties. 3900 DeMooney LLC owned the 25 acres with the house, and then TREF only owned the 5 acres for $150,000. Secondly, the company TREF never sold one of the 25 acres lots for $875,000 because it never owned it to begin with. So right here, it said on September 20th, 2022, the company restructured the property's capital stack by selling one of the parcels for $875,000 consisting, let's just stop there. TREF never sold this property. It went from 3900 DeMooney LLC to South Fulton Rentals Group LLC to Jay Morrison. TREF never sold this property. It went to 3 entities controlled by Jay. 3900 DeMooney, South Fulton's Rental Group, and then himself. TREF never owned this property according to the assessor's website. Now, if the assessor's website is wrong, then we have a miscommunication. But the assessor's website is usually accurate when you're dealing with titles, okay? So the filing states that the value to the company is that it has first right of refusal for all development rights to the property sold. So what it's saying is that TREF has this little 5 acres next to Jay Morrison's 25 acres. And TREF also has the first rights of refusal to develop on Jay Morrison's 25 acres, I guess, if it chooses. But the company does not have enough cash to even complete pre-development. Okay? All the architecture, soft costs, permits, excavation. The company doesn't even have any cash left to do that. So that makes this kind of right not valuable to the company whatsoever. On top of that, now the company is sitting on $150,000, put $150,000 in cash into a 5-acre lot that's just sitting there dead with no plans towards profitability in the future. And in that video, Jay says that we can cut it up and sell the lots. It appears that the fund bought Jay. For me, what this shows, and you come to your own conclusions, it appears that the fund bought Jay Morrison a house in cash on July 27th, 2022, and held it for him for 2 months until September 20th, 2022, okay, when he could refinance the house as South Fulton Rentals Group, LLC. Now, back to the SEC filing regarding the $637,000 refinance, okay? So the company restructured the property's capital stack by selling one of the parcels for $875,000 to Jay Morrison, consisting, but the company never sold the parcel. The company never owned that particular parcel, consisting of a refinance of $637,000 and a cash payment of $238,000. Okay, the company now retains the first right of refusal for all development rights to the property sold without the expense of ongoing debt or carrying costs associated with the long-term hold during the pre-development periods. Based on how this is languaged, it is not clear who refinanced what. Did the company refinance, or did Jay Morrison refinance and then the company gave Jay Morrison a mortgage? If the company sold the 25 acres, why would it need to refinance anything? If the company now sold, let's say it wasn't Jay Morrison, the company sold the 25 acres, what is there to refinance? Okay. Did the company give Jay Morrison the individual mortgage? That's what it sounds like. And if so, at what interest rate? The average interest rate at that time was 7.35% as of May 31st, 2023. Where are the loan terms? Where is the HUD-1? What were the closing costs and loan origination fees? Is the mortgage even recorded? Is a $637,000 mortgage the best way to grow our fund? Why would Jay Morrison go get a mortgage? Why wouldn't or couldn't Jay Morrison just go get a mortgage from elsewhere? Why use the fund's money that we have to multiply at a greater rate than 5, 6, 7, 8% if the transactional funding is working so well? Can we see proof of the $238,000 down payment? Can we see proof of Jay Morrison's monthly mortgage payments to TREF? As of June 30th, 2022, the company only had $1.48 million in cash. So why would it put $1 million in cash into a major development like this 1 month later, okay, on July 27th, 2022? That makes no sense. All right. So again, here is the cash position as of June 30th, 2022. And this transaction took place July 27th, literally 27 days later. So we're going to put 66% of the fund's money, remaining money, the little money that we have left, we're going to put that into huge development and not have enough money for pre-development costs. So to Jay Morrison, back to the 6.92 in the Tulsa Real Estate Fund's company agreement, disclosure states, duty of disclosure. The manager has an affirmative duty to disclose material facts to members. Information is considered material if there is a substantial likelihood that a reasonable investor would consider it important to in making an investment decision. The manager must not make any untrue statements to the members and must not omit disclosing any material facts to the members. The manager has a further duty to disclose conflicts of interest that may exist between the interests of the manager and its affiliates and the interests of the company or any of the individual members. That was violated here. That was grossly violated here. Did you ever disclose to investors that you use company funds to buy your primary residence in cash, or that the company has refinanced your personal residence? If so, when and where? If not, why not? Do you think this transaction, Jay, I'm talking to you, do you think this transaction as the manager, not as a person? Now, I'm not talking to you as person to person. I'm talking to you as the fund's manager. Do you think that this transaction is a violation of your fiduciary duty to investors? What is your plan for this 30 to 32 acres that the company now has the right to develop? So whenever the company is ready to develop, it can come and knock down your house and begin developing? What does that process look like? So the company is now holding $150,000 worth of land and no development plan or cash for pre-development right now. Who gains from that? It seems like the only person who gains from that is you now having your personal residence. And what would the company have to pay you to buy back the land for that future development? Would you profit from that transaction? And if the company gave you a mortgage, which is unclear, and the company goes bankrupt, what happens to the mortgage you owe to the company? Will it resell your mortgage to liquidate and pay investors back? Do you think this deal benefited you or the company most? Is this considered fraud? Is this considered fraud for personal gain, bad faith, intent to deceive, and non-disclosure? In your own eyes, fund manager, Jay Morrison, is this considered fraud for personal gain, bad faith, intent to deceive, and non-disclosure? We really want to know your thoughts and opinions. Now, family, I've gone on for a while now. I really had to share that. I could go on to claim number 2 right now, but I'm going to make this document publicly available. In short, I will run through this really quickly. It says that on January 7th, 2021, we received a payment of $570,000 on related party loan for 2 Parsons Street properties. These Parsons Street properties are actually owned by Jay Morrison, okay, through JM 23 LLC, all right? And such repayment amount includes final draw that was not yet paid and owed to the borrower in the amount of $10,835.30. So the fund owed Jay Morrison through JM 23 a final draw, okay? We were owed by Jay Morrison or JM 23 LLC an exit fee of $23,325. Look at this, y'all. Due to the hardship in the housing industry and on other parties resulting from the COVID-19 pandemic, the parties agreed to mutually forgive the final draw amount and the exit fee. So basically, if you subtract $10,835 from $23,325, that is a $12,000 get out of jail card free for one of Jay Morrison's companies. And it just says the parties, which is basically J and J, okay, mutually forgave. That's $12,000 that the fund is in no position to mutually forgive. And on top of that, this loan, which was originated on July 15, 2019, and it was a 1-year term, you see that right here, a 1-year term at 8%, it still had a balance of $537,000 as of December 31st, 2022. So this loan was late. This loan was overdue. And we want to know if the same penalties that any other developer that borrowed money from TREF would have occurred, would Jay Morrison have occurred. All right. So I have evidence that that's not true, because while Jay was 6 months behind, okay, through Jay or JM 23 was 6 months overdue, right? RVM Acquisitions LLC was only 3 months behind, and it received a deed in lieu of foreclosure after only 3 months. So the fund went after another developer aggressively and got the deed in lieu of foreclosure. But when it came to Jay Morrison's own companies, right, his own real estate investment companies, the fund just was forgiving fees and being patient with him. That is not fair. Okay. That is not fair. And that violates fiduciary duty. All right. So the same standards are not being applied to Jay Morrison's companies as they are to other developers in the fund. All right. So I'm going to let you read through claim 2 on your own when I publish this document. The biggest thing was the acquisition, the sticky, icky, unclear acquisition of Jay Morrison's personal residence through the fund. We would like to see data that shows who actually wired that money to the title company. Was it TREF, or did somehow Jay Morrison do it? Why did the assessor's website show that TREF never owned the 25 acres? And therefore, why the refinance? And then who refinanced what? Did TREF refinance, or did Jay Morrison refinance? And is TREF holding that $637,000 mortgage? These are questions that we don't know. But there's something fishy going on with this particular transaction, and we want answers. So in conclusion, family, we as investors, there are 4 things that I need you to do. All the instructions for that are going to be at tulsarealestatefraud.com. This entire speech will be published at tulsarealestatefraud.com. I need you to submit a complaint to the SEC, right? That takes about 5 minutes, and I've listed out instructions for you. In fact, let me jump over there. I've listed out instructions for you to do that, and you have screenshots of which boxes to check, everything. Copy and paste this text. All of that is here for you. It should take you 5 minutes to do that. Attend the September 5th TREF Talks in person at the Black House. We need investors there. While he made this a public event, it didn't really need to be. This is really for investors, and I encourage you to be in attendance. Initiate your redemption request. Again, all of that is listed here. All of that is listed here. Initiate your redemption request. Click there. Okay. And then finally, share this image on social media if you feel called to. And this is so that we can identify all the investors that are in the fund and reach them. As you see, they closed down the Facebook group so that we can no longer talk after January 17th, 2022. And this is the only way that we can organize and galvanize. And so with that, I thank you so much for your time and your energy. I hope this video has been informative and giving you all the evidence that you need. But I also encourage you to go do the due diligence and research for yourself. Some of these SEC documents, especially for the unsophisticated investors, they're convoluted and they aren't clear and they don't tell the whole story. And so my job, I felt, as a sophisticated investor, was to come in and actually decode that for you, since the fund manager had not been doing that. Now, I made this investment 5 years ago. People saying, Jullien, you're a sophisticated investor. Why did you make this mistake? I believed in a vision, and I believed in Jay Morrison. And I believed that with the power of the 15,000 families, that he would do right by our monies, despite his past. I have a forgiving heart like that. And unfortunately, I was wrong. And that's okay. I forgive my old self from 5 years ago. And for any investor out there who feels like they made a mistake, I want you to forgive your old self from 5 years ago. Because now that you know what you know, now that you know how to read SEC documents, you will make better choices going forward as you make investments. I have not given up on crowdfunding. There are 4 funds that I've invested in, that I'm the lead investor in, that are all successful. This one just happened to be a bad apple in the group. And so I encourage you to all keep the faith, because the only way for us to get free as a collective is through group economics. With that, I want to say thank you so much. I wish you all well, and I hope to see you on September 5th at the Legacy Center. Doors open at 6 p.m. and the show starts, or the board meeting starts, at 7 p.m. Eastern. All right. Again, go to tulsarealestatefraud.com for all the details, for the transcript of this speech, for all the evidence that I presented. And I hope that it serves you and allows you to make the best decision for you and your family. Take care, everybody.